You are listening to MACREADS.com, making justice audible. The narrator for this episode is Mac McCoy. We honor the traditional marshal's cry at the opening of every United States Supreme Court session. Oyez, 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 all draw near and give a listen. Court is in session.
This episode includes the United States Supreme Court's March 28, 2023 opinion in the case of Wilkins v. United States. Justice Sotomayor delivered the opinion of the court. Larry Stephen Wilkins and Jane Stanton wanted quiet titles and a quiet road. Wilkins and Stanton, the petitioners here, both live alongside Robbins Gulch Road in rural Montana. The United States has permission, called an easement, for use of the road, which the government interprets to include making the road available for public use. Petitioners allege that the road's public use has intruded upon their private lives, with strangers trespassing, stealing, and even shooting Wilkins' cat. Petitioners sued over the scope of the easement under the Quiet Title Act, which allows challenges to the United States' rights in real property. Invoking the Act's 12-year time limit, Title 28 United States Code, Section 2409 AG, the government maintains that the suit is jurisdictionally barred. Petitioners counter, and the court holds, that Section 2409 AG is a non-jurisdictional claims processing rule. Part 1. Robbins Gulch Road runs through about a mile of private property. Petitioners acquired their properties along the road in 1991 and 2004. Back in 1962, petitioners' predecessors in interest had granted the United States an easement for the road. The government contends that the easement includes public access, which petitioners dispute. On petitioners' telling, the easement does not allow access to the general public and requires the government to maintain and patrol the road. In 2018, petitioners brought suit under the Quiet Title Act. The government moved to dismiss the action on the ground that the Act's 12-year time limit had expired. Under the Act, any civil action, except for an action brought by a state, shall be barred unless it is commenced within 12 years of the date upon which it accrued. Accrual occurs on the date the plaintiff or his predecessor in interest knew or should have known of the claim of the United States. The parties disagreed as to whether the Act's time limit is jurisdictional, which is relevant to the procedures for litigating whether Section 2409 AG bars petitioner's claim. The district court agreed with the government and dismissed the case for lack of subject matter jurisdiction. The Ninth Circuit affirmed the dismissal for lack of jurisdiction. Applying circuit precedent, the Court of Appeals held that this court had already interpreted Section 2409 AG as jurisdictional in Block v. North Dakota ex rel. Board of University and School Lands. This further entrenched a divide among the courts of appeals. This court granted certiorari to resolve the split and now reverses the Ninth Circuit's judgment. Part 2A. Jurisdiction, this court has observed, is a word of many, too many, meanings. In particular, this court has emphasized the distinction between limits on the classes of cases a court may entertain, subject matter jurisdiction, and non-jurisdictional claim processing rules, which seek to promote the orderly progress of litigation by requiring that the parties take certain procedural steps at certain specified times. The latter category generally includes a range of threshold requirements that claimants must complete or exhaust before filing a lawsuit. To police this jurisdictional line, this court will treat a procedural requirement as jurisdictional only if Congress clearly states that it is. This principle of construction is not a burden courts impose on Congress. To the contrary, this principle seeks to avoid judicial interpretations that undermine Congress's judgment. Loosely treating procedural requirements as jurisdictional risks undermining the very reason Congress enacted them. Procedural rules often seek to promote the orderly progress of litigation within our adversarial system. Limits on subject matter jurisdiction, in contrast, have a unique potential to disrupt the orderly course of litigation. Branding a rule as going to a court's subject matter jurisdiction alters the normal operation of our adversarial system. For purposes of efficiency and fairness, our legal system is replete with rules, like forfeiture, which require parties to raise arguments themselves and to do so at certain times. Jurisdictional bars, however, may be raised at any time, and courts have a duty to consider them sua sponte. When such 11th-hour jurisdictional objections prevail post-trial or on appeal, many months of work on the part of the attorneys in the court may be wasted. Similarly, doctrines like waiver and estoppel ensure efficiency and fairness by precluding parties from raising arguments they had previously disavowed. Because these doctrines do not apply to jurisdictional objections, parties can disclaim such an objection only to resurrect it when things go poorly for them on the merits. Given this risk of disruption and waste that accompanies the jurisdictional label, courts will not lightly apply it to procedures Congress enacted to keep things running smoothly and efficiently. Courts will also not assume that in creating a mundane claims processing rule, Congress made it unique in our adversarial system by allowing parties to raise it at any time and requiring courts to consider it sua sponte. Instead, traditional tools of statutory construction must plainly show that Congress imbued a procedural bar with jurisdictional consequences. Under this clear statement rule, the analysis of Section 2409AG is straightforward. In applying the clear statement rule, we have made plain that most time bars are non-jurisdictional. Nothing about Section 2409AG's text or context gives reason to depart from this beaten path. Section 2409AG states that an action shall be barred unless it is commenced within 12 years of the date upon which it accrued. This text speaks only to a claim's timeliness, and its mundane statute of limitations language says only what every time bar by definition must, that after a certain time a claim is barred. Further, this court has often explained that Congress's separation of a filing deadline from a jurisdictional grant indicates that the time bar is not jurisdictional. The Quiet Title Act's jurisdictional grant is in Title 28 United States Code, Section 1346F, well afield of Section 2409AG, and nothing conditions the jurisdictional grant on the limitations period or otherwise links those separate provisions. Section 2409AG therefore lacks a jurisdictional clear statement. Part 2B. The government does not focus on the text of Section 2409AG, but instead points to a trilogy of decisions by this court that purportedly establish the provision is jurisdictional. None of these three decisions definitively interpreted Section 2409AG as jurisdictional. This court has made clear that it will not undo a definitive earlier interpretation of a statutory provision as jurisdictional without due regard for principles of stare decisis. At the same time, however, courts, including this court, have more than occasionally misused the term jurisdictional to refer to non-jurisdictional prescriptions. The mere fact that this court previously described something without elaboration as jurisdictional, therefore, does not end the inquiry. To separate the wheat from the chaff, this court has asked if the prior decision addressed whether a provision is technically jurisdictional, whether it truly operates as a limit on a court's subject matter jurisdiction, and whether anything in the decision turned on that characterization. If a decision simply states that the court is dismissing for lack of jurisdiction when some threshold fact has not been established, it is understood as a drive-by jurisdictional ruling that receives no precedential effect. The government begins with Block. The case presented two separate issues about the Quiet Title Act, neither of which was whether the 12-year limit was jurisdictional. First, the court held that the act was the exclusive procedure for challenging the title of the United States to real property. Second, the court held that the 12-year limit applied to states. It was only in the opinion's conclusion that, in remanding, the court remarked that if the time limit applied, the courts below had no jurisdiction to inquire into the merits. The opinion contains no discussion of whether the provision was technically jurisdictional or what in the case would have turned on that characterization. There is nothing more than an unrefined disposition stating that a threshold fact must be established for there to be jurisdiction. This is a textbook drive-by jurisdictional ruling that Arbaugh v. Y&H Corps held should be accorded no precedential effect as to whether a limit is jurisdictional. In an effort to endow a fleeting statement with lasting significance, the government and the dissent invoke historical context. Block described the Act's time limit as a condition on the waiver of sovereign immunity. Block never stated, however, that the Act's time limit was therefore truly a limit on subject matter jurisdiction. Yet, according to the government and the dissent, this went without saying because the case law at the time was unmistakably clear that conditions on waivers of immunity were subject matter jurisdictional. This reading is undermined by the very history on which it draws. In Irwin v. Department of Veterans Affairs, the court surveyed the case law about whether time limits in suits against the government are subject to equitable tolling, waiver, and estoppel. If associating time limits with waivers of sovereign immunity clearly made those limits jurisdictional, equitable exceptions would be just as clearly foreclosed. Instead, Irwin described the court's approach to this question as ad hoc and unpredictable, leaving open whether equitable exceptions were available in any given case. Accordingly, even if a statute of limitations was a condition on the waiver of sovereign immunity and thus must be strictly construed, this still did not answer the question whether equitable tolling can be applied to this statute of limitations. The court instead analyzed the specific statutory scheme at issue, with varying results. Block itself reflected the ambivalent nature of time limits for suits against the government. Block recognized that we should not construe such a time bar provision unduly restrictively, which the court quoted just a few years later in support of the proposition that some such limits are subject to equitable tolling. Similarly, while Block cautioned that exceptions to such time limits will not be lightly implied, it did not hold that they were categorically precluded. Block thus acknowledged nothing more than a general proposition, echoed by Irwin, that a condition of the waiver of sovereign immunity must be strictly construed. In Irwin, as elsewhere, this did not mean that time limits accompanying such waivers are necessarily jurisdictional. Next, the government offers United States v. Motaz. Once again, the question presented was not whether the Quiet Title Act's 12-year time limit was technically jurisdictional. The court instead had to decide which of the two possible statutory time bars applied. This analysis proceeded in two steps. First, the court asked which of several federal statutes, the Quiet Title Act, the Allotment Acts, or the Tucker Act, was the source of jurisdiction based on the nature of the plaintiff's claim and the relief sought. The court explained that the Quiet Title Act applied because it was the exclusive means by which adverse claimants could challenge the United States title to real property, and the plaintiff's claim fell within the Act's scope. Second, the court then determined whether the suit was brought within the relevant limitations period. The court concluded that the plaintiff had notice over 12 years before she sued, and her claim was therefore barred. Neither step in the court's analysis turned on whether any time limits were technically jurisdictional. General statements in the opinion about waivers of immunity cannot change this basic fact. At the outset of its analysis, the court observed that the terms of the United States waiver of sovereign immunity define the extent of the court's jurisdiction, and that a statute of limitations constitutes a condition on the waiver. Neither of these statements, however, played a role in determining which statute applied or whether the plaintiff brought her claim within 12 years after it accrued. There is also no indication in the opinion that the parties raised tolling or other equitable exceptions. As such, the legal character of the time limit was never at issue. The government also points to Motaz's procedural background section. Buried in a paragraph recounting a tangled procedural history, the court remarked that the government raised the Quiet Title Act apparently for the first time in a petition for rehearing. This supposedly reveals that the court sua sponte and sub silentio raised, considered, and rejected an argument that the government had forfeited the Quiet Title Act's time limit, doing so all because the time limit was jurisdictional. Yet a background section is an unlikely place for such a ruling. This is particularly true where, as the word apparently indicates, the court did not pause over its passing remark. Nor did the court mention this again. Further, even if the court had secretly considered forfeiture, there were non-jurisdictional reasons the court could have concluded forfeiture did not apply. Speculating about what this court might have thought about arguments it never addressed needlessly introduces confusion. This court looks for definitive interpretations, not holdings in hiding. Finally, there is United States v. Beggarly. The court in Beggarly addressed whether Section 2409 AG could be equitably tolled. Subject matter jurisdiction, as noted, is never subject to equitable tolling. If Block and Motaz had definitively interpreted Section 2409 AG as subject matter jurisdictional, the court could have just cited those cases and ended the matter without further discussion. Instead, the court parsed the provision's text and context, concluding that by providing that the statute of limitations will not begin to run until the plaintiff knew or should have known of the claim of the United States, the law has already effectively allowed for equitable tolling. Also relevant were the unusually generous time limit and the importance of clarity when it comes to land rights. This careful analysis of whether the text and context were consistent with equitable tolling would have been wasted words if the court had already held that Section 2409 AG was jurisdictional. Precisely because the court's inquiry was so focused on the particular nature of equitable tolling, Beggarly also did not address whether other exceptions, such as fraudulent concealment or equitable estoppel, might apply, as Justice Stevens noted in his concurrence. If anything, Beggarly's discussion of non-jurisdictional reasons why tolling specifically was unavailable indicates the court understood Section 2409 AG not to be jurisdictional. Thus, Beggarly undermines any notion that Bloch and Motaz had put the jurisdictional question to rest. All three cases therefore point in one direction. This court has never definitively interpreted Section 2409 AG as jurisdictional. For similar reasons, the government's argument about legislative acquiescence is unavailing. Congress amended the Act in 1986 to provide special rules for states in the wake of Bloch. Then, as now, none of our decisions established that the time limit was jurisdictional, so there was no definitive judicial interpretation to which Congress could acquiesce. The mere existence of a decision employing the term jurisdiction without elaboration does not show Congress adopted that view, nor can the government's handful of lower court opinions stand in for a ruling of this court, especially where some of these decisions contain only fleeting references to jurisdiction. All told, neither this court's precedents nor Congress's actions established that Section 2409 AG is jurisdictional. While the government warns that revisiting precedent results in uncertainty, no revisiting is necessary here. Far more uncertainty would follow from the government's method of divining definitive interpretations from stray remarks. Section 2409 AG is a non-jurisdictional claims processing rule. The Court of Appeals' contrary judgment is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Thomas, with whom the Chief Justice and Justice Alito join dissenting. The doctrine of sovereign immunity bars suits against the United States, but in the Quiet Title Act of 1972, Congress waived this immunity and consented to suits against the United States in order to determine the status of disputed property. Congress conditioned this consent on, among other things, a 12-year statute of limitations. Any civil action under this section, except for an action brought by a state, shall be barred unless it is commenced within 12 years of the date upon which it accrued. This court has long construed such conditions on waivers of sovereign immunity as jurisdictional, and it has acknowledged the jurisdictional nature of the Quiet Title Act statute of limitations in several precedents. In holding that Section 2409 AG is not jurisdictional, the majority commits two critical errors. First, it applies the same interpretive approach to a condition on a waiver of sovereign immunity that it would apply to any run-of-the-mill procedural rule. Second, by reading the court's prior Quiet Title Act precedents in this way, the court disregards their express recognition of the jurisdictional character of the Act's time bar. Accordingly, I respectfully dissent. Part 1. This court's skepticism of the jurisdictional character of procedural bars does not extend to conditions on a waiver of sovereign immunity. In the context of a waiver of sovereign immunity, the court presumes that procedural limitations are jurisdictional. The Act's time bar is one such provision, and, as such, this court should interpret it as a jurisdictional bar to suit. As a sovereign, the United States is immune from suit save as it consents to be sued, and the terms of its consent to be sued in any court define that court's jurisdiction to entertain the suit. Consequently, sovereign immunity is, by nature, jurisdictional. This principle is long-standing, and the majority does not dispute it. A necessary corollary of this rule, however, is that when Congress attaches conditions to legislation waiving the sovereign immunity of the United States, those conditions must be strictly observed, and exceptions thereto are not to be lightly implied. Thus, in many cases, this court has read procedural rules embodied in statutes waiving immunity strictly, with an eye to effectuating a restrictive legislative purpose when Congress relinquishes sovereign immunity. In United States v. Dalm, the court reaffirmed this settled principle in the specific context of a statute of limitations requiring that a suit against the government be brought within a certain time period. Such a requirement, the court explained, is one of the terms of the United States consent to be sued, and, therefore, defines the court's jurisdiction to entertain the suit. Those straightforward principles resolve this case. The Quiet Title Act partially waives the immunity of the United States by granting federal district courts exclusive original jurisdiction of civil actions under Section 2409A to quiet title to an estate or interest in real property in which an interest is claimed by the United States. This provision's cross-reference to Section 2409A incorporates several conditions on this waiver. For example, the Act specifies that the United States shall not be disturbed in possession or control of contested land pending a final judgment or decree, the conclusion of any appeal therefrom, and 60 days. And if the final determination is adverse, the United States shall have the right to purchase the land for just compensation. Similarly, the Act provides that any civil action against the United States under this section shall be tried by the court without a jury and bars suits based on adverse possession. It also incorporates the time bar at issue here. Any civil action under this section, except for an action brought by a state, shall be barred unless it is commenced within 12 years of the date upon which it accrued. Such action shall be deemed to have accrued on the date the plaintiff or his predecessor in interest knew or should have known of the claim of the United States. These provisions carefully delineate the scope of the Act's limited waiver of sovereign immunity, establishing conditions on which the United States has consented to be sued. The United States has not, for example, consented to a jury trial or to be sued on an adverse possession theory. Similarly, and just as critically, it has not consented to be sued except by a state once the 12-year statute of limitations is passed. The majority acknowledges that these restrictions must be strictly construed, yet it concludes that the time bar should not be considered jurisdictional. In another context, the majority's conclusion is arguably plausible, but in this context, it is simply incorrect. As a condition on the United States' limited waiver of sovereign immunity in the Quiet Title Act, the Act's statute of limitations is jurisdictional. Moreover, in light of this court's long-standing case law, the jurisdictional character of the time bar would have been well understood by the 1972 Congress. With no answer to the court's long-standing view that conditions on waivers of sovereign immunity are jurisdictional, the majority seeks refuge in Irwin v. Department of Veterans Affairs. Irwin considered whether equitable tolling should apply to the time to file an employment discrimination lawsuit against the government under Title VII of the Civil Rights Act of 1964. There, the court reasoned that time requirements in lawsuits between private litigants are customarily subject to equitable tolling, and that once Congress has made a waiver of sovereign immunity, making the rule of equitable tolling applicable to suits against the government in the same way that it is applicable to private suits, amounts to little, if any, broadening of the congressional waiver. It thus concluded that such a principle is likely to be a realistic assessment of legislative intent, as well as a practically useful principle of interpretation. The majority suggests that Irwin stands for the proposition that a condition on a waiver of sovereign immunity must be strictly construed, but then goes on to argue that it is not necessarily jurisdictional. However, our decision in United States v. Williams, decided 5 years after Irwin, demonstrates that statutes of limitations in suits brought against the United States are no less jurisdictional now than they were before Irwin. In Williams, the court cited Dalm's holding that failure to file a claim against the government for a federal tax refund within the statute of limitations period operates as a jurisdictional bar to suit, and the court reaffirmed that a statute of limitations narrows the waiver of sovereign immunity. Irwin, thus, does not disrupt this court's long-held understanding that conditions on waivers of sovereign immunity are presumptively jurisdictional. Part 2. Regardless of whether conditions on waivers of sovereign immunity remain jurisdictional post-Irwin, we have said that, where the court has offered a definitive earlier interpretation of a statutory time bar as jurisdictional, We will continue to treat it as jurisdictional unless and until Congress directs otherwise. And we have emphasized that Irwin does not imply revisiting past precedents. The John R. Sand and Gravel Co. versus United States standard is amply met here. This court concluded in Block v. North Dakota ex rel. Board of University and School Lands, and again in United States v. Motaz, that compliance with the Quiet Title Act's 12-year time bar is a jurisdictional prerequisite. Block considered whether the Act's statute of limitations applied to state litigants. There, the government had argued that the plaintiff's failure to sue within the 12-year deadline established by the statute meant that the district court lacked jurisdiction to consider the plaintiff's claims. In assessing this argument, the court made clear that it understood the Act's statute of limitations to arise in the context of a waiver of sovereign immunity, discussing at some length the trade-offs proposed as Congress deliberated over the scope of the Act. The court also prominently invoked United States v. Sherwood and Lehman v. Nokshian, cases discussing the jurisdictional nature of sovereign immunity waivers, to explain why the limitations provision must be strictly observed. After concluding that states were not exempt from the time bar, the court stated that, if North Dakota's suit is barred by the statute of limitations, the courts below had no jurisdiction to inquire into the merits, and it remanded for the lower courts to determine whether the suit was so barred. This statement that the time bar went to jurisdiction was an integral part of the court's instructions on remand. Moreover, on remand, the Eighth Circuit understood the court to have used the term jurisdiction to refer to a court's authority to hear the case. In Motaz, 3 years after Block, the court again considered the jurisdictional nature of the Act's time bar. In the lower courts, the government initially defended against a somewhat opaque set of claims by relying on the general 6-year statute of limitations for actions against the United States. The district court held that the suit was time-barred under Section 2401A, but the Eighth Circuit reversed and remanded. The government then argued for the first time in its petition for rehearing in the Court of Appeals that the suit arose under the Quiet Title Act and was thus subject to the Act's 12-year statute of limitations. This court granted certiorari to consider whether the respondent's claim was barred under either the 6-year bar or the 12-year bar. In addressing these, the court cited Sherwood for the proposition that, when the United States consents to be sued, the terms of its waiver of sovereign immunity define the extent of the court's jurisdiction. It then quoted Block for the proposition that, when waiver legislation contains a statute of limitations, the limitations provision constitutes a condition on the waiver of sovereign immunity, treating Block as precedential on this point. The court also characterized the statute of limitations as a central condition of the consent given by the Act. As in Block, this reasoning was a critical and substantial part of the court's opinion. The court ultimately concluded that plaintiff's claim was untimely and thus barred under the Act. The court further concluded that no other statute conferred jurisdiction on the lower courts to adjudicate her claim. In deciding the case, the court noticeably did not engage in a forfeiture analysis, underscoring that it understood the government's late-raised statute of limitations argument to be jurisdictional and thus capable of being raised at any point in the proceedings. United States v. Beggarly, on which the majority relies, is not to the contrary. In that case, the court considered whether the Quiet Title Act's time bar may be equitably tolled. After noting that the Court of Appeals had considered the statute of limitations jurisdictional, the court turned to the language of the Act. The court emphasized that the 12-year statute of limitations began to accrue when the litigants knew or should have known of the claim of the United States, and it observed that the provision's text has already effectively allowed for equitable tolling. Given this fact and the unusually generous nature of the Act's limitations time period, the court concluded that extension of the statutory period by additional equitable tolling would be unwarranted. Thus, while Beggarly might be read to view the Act's time bar as potentially susceptible to tolling, and thus by inference non-jurisdictional, the court did not hold that the bar actually could be tolled. Rather, the court held the opposite. Beggarly is therefore at best ambiguous with respect to the jurisdictional nature of the time bar. As such, it does not overcome the court's clear prior view set out in both Block and Motaz. For the majority, the court's statements in Block and Motaz are not definitive enough to satisfy John R. Sand. but the import of the court's references to jurisdiction in Bloch and Motaz would have been clear at the time. A court in the 1980s discussing a provision of a statute as a waiver of sovereign immunity, citing Sherwood and later Bloch, invoked a well-known set of ideas that readers at the time unmistakably associated with the concept of jurisdiction. In fact, the court in Dalm cited Bloch and Motaz, and no other cases, for the proposition that conditions on waivers of sovereign immunity define the court's jurisdiction to entertain the suit. The court's precedents must be understood in that context. The Quiet Title Act's statute of limitations functions as a condition on a waiver of sovereign immunity, and is therefore jurisdictional. This court has repeatedly characterized the Act's time bar as jurisdictional, and that interpretation remains authoritative under John R. Sand. Accordingly, I respectfully dissent.
You've been listening to MACREADS.com, Making Justice Audible. The narrator for this episode was Mac McCoy. Please like, follow, subscribe, review, and share our work wherever you access your favorite podcasts. This audio recording provides general information. It is not a substitute for legal advice from a licensed legal professional. This audio is modified from the written source material to remove content not suitable for audio presentation. Please consult the written source material for these additional details. Until next time, thank you. Court is in recess.